Hello, my audience across the globe. You are welcome to another in-depth analysis and updates following Nnamdi Kanu, a breach court case today. It was slated for 10th of October. Eventually, Justice James Omotosho abridged the case to hold today. And from the court proceedings, Justice James Omotosho dismissed Nnamdi Kanu no case submission and under Nnamdi Kanu Defense Counsel to open a defense. Now, the question here is, Nnamdi Kanu should open a defense for what? That is important. What will Nnamdi Kanu open defense for? Is it on his extraordinary rendition, which violates his fundamental rights and privileges, which Nigerian government grossly violated by his extraordinary rendition and torturing him, which a competent court of law within the Nigerian legal jurisprudence has discharged and acquitted Nnamdi Kanu bordering on the 15-count charges that was reviewed 8 good times, and yet no evidence, substantive evidence could be tendered before the court, which eventually led to the dismissal of those allegations, and eventually passed a verdict or ruling in favor of Nnamdi Kanu. Now, when Justice James Omotosho dismisses the no case submission, what exactly did he intend Nnamdi Kanu to do? To file a defense for what? That should be the concern of everyone. And the world is watching, of course, following up this debate and this most controversial injustice has been perceived by majority of people, especially those who believe in the cause of Nnamdi Kanu, that the right to self-defense is not a violation of any known law within the Nigerian state, which Nigeria happens to be a signatory to the United Nations Charter by ratification. Even the vice president in the last year United Nations General Assembly, he made it expressly. He cited the provisions of the Constitution of the United States Charter that self-determination is an inalienable right given to God, to men, that cannot be usurped by any established institution of government. Upon this, Nnamdi Kanu predicated his position and argument. He based his argument based on the provisions of established laws and code of conduct operations. He deployed diplomatic engagements and calling for a referendum to determine the continued existence of his own people within the defined territory known as Nigeria, which they feel being threatened. Their existence, continued existence, is being threatened within the defined territory known as Nigeria, which they have the right to seek for their own self-preservation, preservation of identity, cultural and ideological identities. Well, calling Nnamdi Kanu to put up a defense, for me, it is quite unacceptable, because what is Nnamdi Kanu as a layman? Well, I'm stand to be corrected. If you're a legal professional, let's argue this case. Via the comment section, I want to get your own perspective regarding this. First of all, there is no basis to continue, or there is no justification or any legal ground to continue the trial of Nnamdi Kanu based on his extraordinary rendition, which was grossly violated by the Nigerian government, which also was affirmed by the Kenyan courts. He was tortured which is against his right to self-defense and fair hearing, and if subsequently arraigned in the court of law. So eventually, the court have ruled in this case not once, not twice. The high courts in Enugu in Abia State also ruled the case before an appeal court of higher jurisdiction has to rule the case, despite the fact that Nigeria lost its jurisdiction because a crime Nnamdi Kanu allegedly was accused of was not done within the Nigerian jurisdiction. It was done in the United Kingdom, in the UK. So Nigeria lost its jurisdiction to to preside over such case, where the alleged broadcast or incitement was done in United Kingdom, which is outside the Nigerian legal jurisdiction, and being that again, losing its jurisdiction has no right to try Nnamdi Kanu based on the alleged crime, and also the fact that the extraordinary jurisdiction, of course, made Nigeria to lose outrightly the legal right, the right to preside over Nnamdi Kanu case. So the case, no case submission was well articulated, and the only reason why Nnamdi Kanu should appear in the court in the first instance. So for the legal counsel to have filed no case submission, to set aside all the count charges, even the DSS masked witness could not establish any incriminating evidence against him. He said he was found with microphone and the rest of them. There was no any incriminating exhibit suggesting any intention for act of terrorism. So on what basis do you establish your verdict against him? From my own assessment of following the trends of events, I understood that the Nigerian government has nothing, of course, to indict Mazi, has no case with Nnamdi Kanu, possibly using the system to delay, well, as some persons have expressed dissatisfaction and disappointment over Justice James Omotosho, who people are skeptic about his personality and whether Nnamdi Kanu will definitely have justice. Well, asking Nnamdi Kanu to put up a defense and dismissing the no case submission is more or less trying to rewind, of course, extend the already prolonged case. It's a way of buying time, by my own opinion and observation, and possibly consider Nnamdi Kanu health condition. Given 8 days for his medical records to be brought before the courts, what has the court to do with the medical reports? And why should that be deferred to 8 days in a state of emergency? The Nigerian Medical Association have carried out their investigation, and it is quite incriminating. The revelation they made, the findings they made, that Nnamdi Kanu needed critical attention. Does it mean that even the judges, Justice James Omotosho, do not understand what that means when somebody needs a critical examination, medical attention? Well, it is quite very unfortunate that all this are playing out. The people are watching, and some have argued that this is a declaration of war against the Igbo, and sadly, some Igbos are also fighting Nnamdi Kanu not to be released. So I may not totally agree with that submission, because some Igbo people are fighting. Those who, for political and obvious economic reasons, wouldn't want Nnamdi Kanu to get out of office. These are Igbos. So you couldn't say that this is a fight against Igbos, but certainly majority of the Igbos are in support of Nnamdi Kanu and his ideology or what he represents. justice for his people, which is being perceived within Nigeria that the Igbos have been sidelined. And evidence, of course, abounds to that reality since independence. Most sadly, after the bloody uh, civil war that lasted for 3.5 years, despite the no victor, no vanquish, and the rest of them, history, of course, has it all. The reason why the likes of Mazin and the Kanu decided to say no. Our fathers weren't treated well, otherwise, there wouldn't have been need for the declaration of the uh, Afara Declaration of the independent state of Biafra by the late Dean Chukwemeka Ogochukwu. And Njibo. It was as a result of gross injustice, mass murder of the Igbos across the entire northern region and some part of the west, that prompted Ojukwu to say, no, if we continue in this way, there may not be a remnant of the Igbo race. And of course, have to put up resistance to defend their own life, their inalienable right to live, which eventually Gowon, in his 90s now, declared war operation, clamped down against the Biafrans, even the defenseless majority of the citizens, suffered cruel and brutal assaults, genocide, where over 5 million people were recorded dead, lost their lives. Children were starved to death. Of course, these are war crimes and which should have been provided. And those concerned should have been arraigned in international criminal courts. Sadly, do we really have international criminal courts? We are then really consigned and dedicated in dispense of justice for all, possibly just for selected few. If I'm not mistaken, probably the white skins. Otherwise, such genocide would have been on record, and of course, demand for justice and the cry for justice over this 5 million children and the rest that was lost in that very unfortunate and avoidable war, of course, should have been addressed. Now, it is left for Nnamdi Kanu and the Defense Council to eventually decide otherwise. And depending on whatever be the outcome of that, well, of course, it shouldn't be a surprise as one of the lead counsel have expressed that ahead of time, that if eventually the no case submission was dismissed, then you now put up a proper defense, which reference should be made in the previous court's rulings and verdict that was given. Yes, Nnamdi Kanu, lead counsel or defense counsel, will definitely put up defense as had been earlier briefed. Or they have earlier briefed the masses. If you are following, of course, videos and programs, you should have gotten that information. There's nothing too wrong about the no case submission. But for me, I don't consider it necessary to continue the trial because there's no basis for establishing the allegation against Nnamdi Kanu. They have tried it in the first instance and eventually ended up, it's just a matter of buying time. Well, of course, let's see how that goes, and eventually the defense counsels are ready for this time. It shouldn't come to them as a surprise. And I believe with this length of time, they have been studying this case, and eventually today, we are hearing whatever has happened. Possibly Nnamdi Kanu will still have his freedom and justice must be served. It doesn't matter, of course, whatever is played out, but strongly we believe that justice must be served. If Nigeria is considered a democratic government or process, then which is anchored on justice and the rule of law and the defense of fundamental rights of humans, then we should expect that the neutral should be done in the midst of all this. And Mazen Nnamdi should be given the adequate and appropriate medical attention he needs and deserves as a human and not as a condemned criminal, because there has not been any court of law within the Nigerian legal jurisprudence, whether in the past or present, that have convicted Mazen Nnamdi of any known crime. Rather, cases has been ruled and won in his favor. It is quite an interesting moment to watch as we continue to get, of course, across whatever development and analyze issues and cases. Possibly, we shall be briefing or bringing updates and the way forward for this no case submission that was set aside for the proper defense to begin. Then the Nigerian government will be able to establish whatever allegation levied against Mazen Nnamdi, which I strongly believe is has no basis and could no longer be substantiated. There are two important factors, hurdles, which the Nigerian government or the defense prosecuting counsel cannot surmount. One is the issue of jurisdiction. You are accused that somebody did something in UK. So you have no right jurisdiction to try him here. And again, his extraordinary rendition was totally out of place. You cannot be a beneficiary of the law you break or take advantage of the illegality you involve or indulge in. That is double tragedy. And someone who has been set aside, discharged and acquitted cannot be subjected to endless trial. In court, for those who know better, is described as double tragedy. Well, only time will reveal, of course, whatever might be the way forward, but then this might take another season. Keep on adjournment and adjournment, these tactics, and eventually, let's see how that goes. Whatever be the case, we'll be here to continue the interactions, and let's have your own take regarding this update. How do you feel? What is your intake? Was that as a surprise to you, or does it come as a shock? And what do you think? Of course, in the coming days, we might be seeing or eventually might be unfolding. Thanks for watching.